Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your hosts Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Good morning, everyone. Welcome to the Bottled Business Sense Show. Today is Tuesday at 10 a.m. We want to welcome all of our returning viewers and listeners out there, and also welcome our new viewers to the show. We are the Bottled Business Sense Show, and we provide free information in regards to legal topics, marketing topics, business coaching topics to help improve your small business run efficiently, safely, and efficiently. And so between myself and my other two co-hosts, Steve Smith and Mr. Bill Bernard, who we have on the show today, we want to offer this free advice to you, free. If we have a number of different topics that we've done over the last couple of years, and you can always go to our website at bottledbusinesssenseshow.com and take a look at our resources there. A whole plethora of information that we've provided to the small business owner like yourself. And along those lines, we're going to do the same thing here today. So with that, I'm Rick Moscoso with Captivate 365 LLC. And I want to introduce my co-host on the other side, Mr. Bill Bernard with WFB Legal Consulting, Inc. Bill, how you doing today?
I'm doing great, Rick. Thanks. Great introduction. Yeah, we're every situation is fact specific to each person who listens to the show, and we can't cover all of those bases, of course, but what we try to do, as Rick said, is give general information with the appropriate disclaimer that obviously you need to seek out and speak to an attorney on a legal issue you may have that's specific to you, and a marketing issue that may be specific to your business with the appropriate individual in that area. But having said all of that, this is, as Rick said, free information. We try to provide it as a public service, and hopefully it'll allow you to incorporate these principles into your business and allow the business to be protected and profitable. And that's the whole concept of the Bottled Business Sense Show. It's bottled business tips, and think of the ship in the bottle that's sailing along and is protected. That's your business. In any event, today's topic that I thought we'd explore, Rick, is really going to involve a hot button issue that I get a lot of questions about. Believe it or not, most employees, I shouldn't say most, but many employees really are not clear on what their personnel file consists of, when they are allowed to inspect or copy the personnel file. And likewise, employers are not always sure when they're supposed to release personnel files, and if so, how they're supposed to do it. So today, we're going to cover 6 major areas that encompass the California Labor Code sections dealing with personnel files, and hopefully provide a roadmap, if you will, for the employees and the employers out there who need to know this information is really critical to the operation of their business.
That's great. I know there's a myth out there from the employee side that, well, like you said, they're not clear if they actually have the right to see their own file, which you're going to go over today. But I guess I'm surprised at how often you get that inquiry that they don't know what they're entitled to see what is being said or what's being documented on their behalf.
Well, that really stems from a twofold type problem. One, on the employee side, most people are concerned about their job. They want to do a good job. They're in there working all day. They don't have a lot of time to think about other materials that may encompass their work history, and sometimes they don't even read employee handbooks when they're presented to them by the employer. And then the second issue is the employer may not always have the appropriate things in place to make sure the employee is aware of what his or her rights are, especially with regard to the personnel file. And critical to that is, of course, as I mentioned, an employee handbook, which should specify under what conditions you are entitled to see your personnel file. So let's start off by just giving a small history of the California Labor Code. For years and years and years, the Labor Code allowed employees to inspect their personnel files, inspect them, look at them, and only copy a document which was signed by the employee. So you could only get copies of exactly what you signed, whatever that may be, like maybe an employment review or something of that nature, that was in the personnel file, and then you could inspect the entire file. Well, as of January 1st, 2013, the legislature in California expanded the right to review personnel files and created new obligations on the part of employers and employees on how to access that expansion, if you will. And the first major area of the 6 we're going to cover is records request procedures. And that involves inspecting or receiving a copy of personnel files that the employer maintains relating to an employee's performance or any grievance or anything of that nature. And the first thing we really want to hone in on is that this request must be in writing. So you can receive a copy of your personnel file if you request it in writing. Now we're going to talk about current employees, people that are still employed with their employer. And if you want to copy the file, which you now have a right to do, the employer has a right to make you pay the copying costs of whatever that is. Remember, I want to at this juncture impress upon everybody that under the prior law, employees could only request copies of documents they actually signed. Now, as of 1/1/13, you get to copy the entire file, although it must be made in writing. A request must be made in writing, and of course, the employer may, if he chooses, require you to pay the copying costs.
So is there anything in here in the employee file as of this change that would not be able to be shared?
Well, yes, and we're going to get to that at the end of the broadcast. But I'll give you just a hint. Any kind of a criminal investigation that's being conducted against an employee, the employee is not allowed to see any of that information.
Okay,
that would
so
be
pretty much so now it's pretty much everything that's in your own personal file. You have the right to be able to look at and see.
Pretty much everything, with some minor exceptions, which we'll get to. The law also allows employers to designate a specific individual to whom these requests must be made. So you can't just go into your place of employment and request your personnel file. You should speak to somebody specifically, either a supervisor or someone in the HR department or whoever that employer designates to make the request to. And also the employer is required to develop a form which needs to be filled out by the employee in order to make this request, because again, it has to be made in writing. So why not have a form that is utilized for that purpose? Now understand, the employer needs to make this form out. However, it doesn't mean that the employee can't request something in writing by way of a different means, a letter or a memorandum or an email, okay? If the employee doesn't choose the form that the employer is required to provide, that doesn't mean that the request is not in writing if it is in writing in some other fashion. And finally, under this first category, we want to emphasize that the right to inspect or obtain copies of personnel files does not apply to employees covered by a collective bargaining agreement. That's a whole different ballgame. A collective bargaining agreement is something that's negotiated typically in union scenarios, and you'd have to look to the collective bargaining agreement and the terms of that agreement in order to determine what and when you have access to what personnel documents. And that's something that we're not going to cover in this show because collective bargaining agreements are way above and beyond what we want to talk about today. So let's go on to the second category. Now you get your request in writing. How does the employer respond? Well, again, previously, you were only required to respond, and here's a great legal phrase, right? We hear it all the time, quote, within a reasonable time, unquote. No one really understood what a reasonable time is, although you could assume that maybe after 30, 60 days, you're getting into the point of not being very reasonable in response to your employee's request. So here we split it up. This second section about how to respond to employee requests, we're going to split up into current employees and past employees. So let's tackle the current employees first. Very simply, you must respond to a current employee's written request to see their personnel file or copy their personnel file within 30 calendar days upon receipt of the request. Pretty basic, pretty standard. Now, the employer and the employee can agree to extend this deadline if they want to, but here's the interesting feature. You can only agree to extend it 5 days, which means that the maximum would be 35 days pursuant to an agreement, and that's 35 calendar days, okay, not business days. So the records must then be made available for inspection where the employee, the current employee, reports to work. Again, unless the employer and employee agree on a different location. So you want your personnel file, you make the request to me in writing. I have to make it within 30 calendar days, possibly 35 if we agree to extend it by 5 days. And it has to be made available to you at your place of employment unless you and your employer agree to provide it for your inspection at a different location that you can both agree on. This different location has to be within a reasonable distance. But more importantly, the employer is not required to make the file available to you when you're supposed to be working. He doesn't have to take away from the work time that you owe him or her merely because you made this request. However, if you provide that you can inspect or copy these records at a location that's different from where you work, and that requires you to take off from work to go to that location, you can't suffer any wage loss as a result of that.
Okay, so I have a comment and then a question. So
sure, go ahead.
The comment is if you are working for an employer locally, 30 days seems to me like a long time, right? If they're doing their record keeping properly, why, it should be readily available in a shorter amount of time. So that's just my observation. This, go ahead.
Yeah, you have to, you don't know how large this file is. Believe it or not, in a short period of time, an employee can get into a lot of hassles with his employer. You don't know how big this file is. It does require copying. It does require somebody to take time away from their typical duties to make the copying. It allows the employer to review the file and make sure that certain things that aren't supposed to be turned over are removed. It allows for the redaction of different names of people who don't have anything to do with your supervisor's position and all of those things. It allows for an employer to consult with his or her attorney. So the 30 days is not unreasonable in my estimation.
Oh, okay. So the question I have is, all right, say you're in a sales position with a company that has out here on the West Coast, and you happen to be working for a company out on the East Coast. All of the HR, the mothership is on the East Coast. Your immediate sales manager is, let's say, in Denver, right? What happened? How do you handle that distance or location in trying to acquire the, trying to view your files when you're in that type of situation?
Well, it depends how the employer has this set up. You could make a request directly to Denver. by way of email or by way of downloading the form that the employer creates and sending that over. Or you may have the ability, pursuant again to the employee handbook, you may have the ability to make the request locally right there where you work. And if I'm the employer and I'm a smart employer, I'm sending copies to the Denver main office and keeping copies of exactly what I send them, a duplicative personnel file, in other words, at the local place where the employee is. That's what I would do. Now, that's not necessarily, but there would be policies set up by the employer to allow access. Doesn't matter whether you have to make it into Denver or to the local place where you're working. You better produce that file within 30 days.
Yeah, right.
That's the bottom line.
Right.
Now, interestingly enough, again, staying with current employees, an employer is not required to comply. Are you ready for this, Rick? This will surprise you, I'm sure. Employers not required to comply with more than 50 inspection or copying requests during one calendar month. So you got 50 chances. You could make 50 requests. You can make 50. Now, I think it's fair to say you may have a problem employee if you've got somebody making those many requests. But that's an interesting feature of the law as of January 2013.
Who was the lawmaker that came up with that number?
Let's see. Remember, the California legislature California as a state has typically always been a very liberal state. It's on the cutting edge of employee benefits. It's beneficial to the employee. It watches out for the employee. It wants to make sure that that people who are in a working scenario don't get messed with, in other words. Now, whether that's to each and every employer's personal taste, that's another matter, and that's you got to comply with the law. Yeah. Now let's jump over to former employees. An employer is only required to comply with one request per year. Employee he wants to copy or inspect their personnel file. Just a year. Again, the request must be in writing. Okay. And the employer has 30 calendar days to produce the records for inspection or to provide copies at the location where the employer stores the record, again, unless they agree in writing to another location. However, the former employee, since the former employee is not present anymore at the place of employment, can request a copy of these records by mail as long as he or she, of course, pays the required postage. Okay? So some of this may seem a little tedious, but this is important stuff. If you need your records, you need to know how to get this stuff.
Yeah.
Now, if the former employee was terminated for a violation of law or for a violation of a company policy involving, for example, harassment in the workplace, the employer may comply with the request for inspection or copying of records by mailing them within a reasonable, to a location other than the workplace, wherever the former employee designates, or to a place that is within a reasonable distance of the employee's a residence. So you're living at home, you request the personnel files, you're a former employee, you wanted to go to your attorney's office, or you wanted to go to some other friend. For whatever reason, you wanted to go somewhere other than your residence. It has to be within a reasonable driving distance. I wouldn't place too much emphasis on that because typically an employer-employee can work that stuff out, and most former employees that I know want the records to go by mail rather than delivery, and they want it mailed to their attorney if they have one, or themselves at their personal residence. And here's what you were asking about before, Rick. An employer may redact the name of non-supervisory employees. So if you have some report that involves information about another employee, whether former or present, that employee's name can be redacted as long as that employee was not one of your former supervisors, because typically supervisors are involved in making decisions about your well-being in the workplace. So the employer may take reasonable steps to verify your identity if you're a former employee. Okay, so now, and again, this is easily done by maybe providing your social security number, maybe by contacting them by phone, something that will satisfy the employer's concern, if they have one, that this is not just some willy-nilly request being made by some crackpot who wants to get the ball rolling on a lawsuit, perhaps without the former employee even realizing. And finally, if the employee files a lawsuit, the right to inspect or receive copies of these records is terminated pending the lawsuit, while the lawsuit is pending. So what happens? If you're involved in a lawsuit and you want your personnel file, you request it prior to the time the lawsuit is filed, right?
Mm-hmm.
Because you want to get it before the lawsuit is pending. Now, I would say to you as a litigator that if I do a request for production of documents to the other attorney and I'm representing the employee, that attorney is more than likely going to produce a copy of my personnel file. But the real point being made here is you want to get it before you institute the lawsuit so you know what information is available to you. That helps you evaluate whether you even want to file a lawsuit, right?
Mm-hmm. That's right.
So that's important. So we have employees, current employees, and former employees that we need to be aware of in terms of how we deal with providing these records for inspection and or copying. And that takes us on to the third area, record keeping and penalties. And this is an area employers need to know about because they must retain copies of an employee's personnel files for at least 3 years after termination of employment. At least 3 years after termination of employment. Any violation under the labor code could carry a penalty of $750 per violation. And the former employee could bring injunctive relief, forcing you to provide the file if you don't do so. So this is a very short section, this section 3 that we're talking about, but I wanted to make sure that employers are well aware of this because it's important for them to know.
Yeah. Now, let me ask you this. We're talking about employees of the workplace. Now, the same record keeping wouldn't apply for a independent contractor, would it?
No, you wouldn't have any reason to have any. You wouldn't have any files on an independent contractor other than a business file and the work invoices and things of that nature that you deal with on an everyday basis. If you do, this may call into question a prior show that we did, independent contractors versus employees. You have to look at a number of factors. You may have misclassified somebody as an independent contractor when they're really an employee. So all of those factors, I would urge people to go back and watch that other show to determine what the distinctions are there. And that of course is on our website. The fourth area is, okay, what's in a personnel file? What is the personnel file per se? There's 2 categories of records that employers must make available pursuant to the California Labor Code. One is any records relating to an employee's performance. Anything. So we're talking about complaints, we're talking about annual reviews, any notations leading to reviews, any memorandums, any disciplinary action, things of that nature. And of course, the second category I've already covered actually. Records relating to any grievance that was filed by the employee. The Labor Commissioner, the California Labor Commissioner, has broadly interpreted these 2 categories that I just mentioned into the following: employment applications, performance reviews, attendance records, qualifications for promotion, additional compensation or compensation records, any records involving disciplinary action, any records that involve reasons for termination. So this is a pretty wide specter. And then that brings us into area number 5, Rick, and that's what you asked about. What are the exceptions to employee personnel files, and more specifically, what employees do not have a right to see? And that would be letters of reference, maybe that are in the file. Number two, any records of a criminal investigation that's being done, right?
Yeah.
And number three, any records from prior employment. Maybe your prior employer has sent over stuff to your current employer. You better get that from your prior employer if it's still within the 3-year period from your termination, and if that prior employer has kept the records. So those are things you're not entitled to see. Any examinations that you took, promotional examinations, are not typically included. And finally, and most importantly, number 5, medical information. Medical records must be kept in a separate file because, as you know, we have HIPAA. And pursuant to HIPAA, you have to have express permission to seek those files. Now, you can seek medical files from your employer that involve you, but you can't have those files mixed in and placed with personnel files, because other people may see your personnel file and have a right to it during pending litigation, but they don't have a right to your medical records unless your medical condition is somehow put in issue, and that's a whole different litigation issue for another day. And finally, that leads us, Rick, to the 6th area, suggested compliance actions. And this is really a recommendation I have for employers. Again, another section dealing with employers more specifically and how they should deal with employees and make sure that employees have what they need. Number 1, develop the request form that you're required to develop. Make it easy. Give the employee the request form. What does that do, Rick? That does 2 things. 1, you're in compliance with the law. And 2, isn't it great to be able to give an employee a request form and then be able to say at some point in time, the guy never requested the records. I gave him the request form. Never, I did what I was supposed to do. The employee didn't request the records in case a hit should come up in the future. Number 2, update your employee handbook. Make sure it covers your policies concerning what we just discussed today about personnel files. Number 3, educate your human resource department and your supervisors about this stuff. They need to know this. I mean, it doesn't make much sense if they're not, if they're in the dark. Number 4, designate a specific company representative who receives all of these requests. And number 5, and most importantly, make sure, as we just mentioned a minute ago, that the personnel file contains only the appropriate materials that are supposed to be included in it, i.e. no criminal investigations, no medical records, that sort of thing. So in a recap, if I might, Rick, we've talked about how, record request procedures. We've talked about right to inspect or right to copy within 30 days. This is different than the code before January 2013, when you were only entitled to inspect the personnel file and receive only copies of documents that you actually signed. The second area we talked about is how you respond to requests. We've talked about the 30 days and the 5 additional days that could be agreed upon between the employer and the employee. How many requests can be made per month by a current employee, how many can be made per year by a former employee, and the fact that these requests must be in writing. We've talked about the penalties that could be ensued by the employer if he doesn't comply, he or she. We've talked about what's in a personnel file that would include anything regarding an employee's performance and records relating to grievances, and that opens up a whole scope of subcategory of records that we discussed under those 2 main categories. 5, we talked about what's not included: letters of reference, criminal investigations, records of prior employment. And 6, we talked about just a minute ago, what the employer needs to do to ensure these things are implemented. Make sure you educate your employees, make sure you have a request form, update your employee handbook, and so forth. So I hope this has been somewhat helpful and has answered some questions that, again, I get very often about, hey, what am I entitled to? When am I entitled to it? Am I even entitled to anything? So I've lost the audio on Rick here for a second. So, but in any event, unless we can get Rick back, I hope everyone has, enjoyed the show. I hope somebody has really taken some practical benefit from this, because it's really, really critical to understand for both employers and employees. And we'll be back next week, every Tuesday at 10 a.m. For another edition of the Bottled Business Sense Show. Find us on our websites, Captivate365.com, WFBLegalConsulting.com. You can find us on Facebook, LinkedIn, Twitter, Blog Talk Radio, and of course our website at thebottledbusinesssenseshow.com. So again, everyone, I hope you've enjoyed the show and got some benefit from it. We'll see you next week. And Rick, wherever you are out there, I know you probably can still hear me. Have a great week, and we'll see you all again next week, everybody. Take care.